Please welcome the Ethics for Advisors panelists to the stage, moderated by Jeremiah Williams, partner at Ropes & Gray.
Good morning, everyone. Thank you for joining us for our ethics panel. We hope to keep this interactive and engaging for people, so please feel free to ask questions. I'm going to start off by introducing the panel. My name is Jeremiah Williams. I'm a litigation partner at Ropes & Gray, and I was previously at the SEC in enforcement in the asset management unit. I will start here on my right and move over. Ivy Duke is the Chief Compliance Officer of the National Real Estate Advisors Organization, which is a large-scale urban commercial multifamily projects group in real estate. And then over we have Bob Toner, who very recently joined Edward Jones as principal, and he's the fiduciary legal team leader there. And on the far right, my far right, is Kurt Wachholz, who's a managing director of the Bates Group. The Bates Group is a leading provider of U.S. and global securities litigation support, and they do regulatory consulting. So let me start off with one of my most important jobs of the day, which is to give you your CLE information. So this session is eligible for continuing education credit. The first code word is trustee. That's trustee. And then I'll give the second code word towards the end of the session. So this is the agenda that we hope to cover today. Again, we want to keep this interactive, so if people have questions or want to ask about other things, we're happy to do so. We're going to focus quite a bit on insider trading and material non-public information. We're going to also talk about the SEC whistleblower program and then best practices in terms of compliance. So I was going to start off just giving a little bit of a background on insider trading. I'm going to be brief because I know people are generally familiar with this, so I won't belabor it. But insider trading is trading in security on the basis of material non-public information in breach of a fiduciary duty with scienter, or with intent. And in cases where there's a corporate insider, there's an additional element of a personal benefit. And here on the slide, we have the various ways in which insider trading appears. And it's really, as people know, it's really a patchwork of various laws. So, the core insider trading provision in the federal laws falls under, 10B, Rule 10b-5 in the Exchange Act, which, talks about manipulative or deceptive means in buying and selling securities. But insider trading is also an Advisors Act as far as an obligation to have policies and procedures to prevent misuse of non-public information. And a code of ethics, people have to have policies and procedures, and it's there as well. And there's a requirement in code of ethics to comply with federal securities laws. And then as far as books and records, people have to have records of their policies and then also records of violations. So it really appears in various places, obviously. And then there's also foreign regulations as well. We have the EU market abuse regulation from 2016 on the slide as well. So needless to say, insider trading is important and something that really is present in a number of different provisions. So we're going to start off talking about material non-public information. What's material and what's non-public. The legal standard is, I think most people know, something is material if it alters the total mix of information in a public domain, right? And as people know, there's not really a bright line test. That's one of the reasons that makes the job so difficult for compliance officials is, trying to draw the line and saying what's material and what's not. Non-public has also taken a very interesting turn in our new, social media situation where, information is often distributed in non-traditional ways. And so, the law on non-public is that it has to be widely disseminated and has to be a sufficient amount of time that's out there. So that can be something that's a little bit difficult to determine in our current media landscape.
So, Jeremiah, I want to step in just for
Yes,
a second
please.
and talk about a couple of things. First, how many of you are private fund? Just a show of hands. Okay, and then, so I think when we start talking about insider trading and material non-public information, some of you are going to be right on it because you kind of know what that is, and there are going to be some of you who are going to say, based on our business model, I don't think that's really a problem because we don't maybe have people that serve on boards, or we're not doing deals or those kinds of things. So hopefully as we go through today, we're going to talk about some things to show you how this interacts with your business. You know, when I was first asked to speak on the panel, William called me and said, we're doing a panel on MNPI, and I thought he was talking about my new private island that I created during the pandemic, where I walled off the rest of my family so I could do compliance work. But then he said, no, it's material non-public information, and I said, that's going to be really exciting. So I'm glad you guys are here this morning to talk about this topic. But I want to start, because we've got a lot of things that we're going to talk about related to this. I think sometimes to learn is helpful to give you a scenario. So I'm going to start with just giving you a scenario, and then as we go through this material, we're going to come back to it to show you how it impacts you, okay? So what I'm about to tell you is all hypothetical, except the things that I've made up. So during the pandemic, we all were working remotely. So let's assume at our business that an employee decided as the pandemic ended that they were going to throw a party at their house for some of the co-workers because they all wanted to get back together and see each other face to face, okay? So they have this event at the party. The co-worker has a live-in partner. While they're at the party, some of the people are standing around and talking about their experience during the pandemic, and this partner says to a group of people that were standing around how they work at a pharma company. And the pharma company, she's in the drug testing area, all right? They're working on something because there's this thing going around, and they have a solution for it, and they've gone through some trials. But they've learned that the experience in the trials, now that they've been doing it for longer, has been different than what they started out, and they may actually have to reassess the results of their program. So they've talked about it. How many would say that is MNPI? Okay, sounds like it. Great. All right, so we're going to come back to that. But the important thing we're talking about now is, do you know what MNPI is? So that's the first thing we talked about. And then insider trading, as Jeremiah started with, is I want you to underline that idea of personal benefit. So write that down. That's important to know. MNPI, remember, is how do you know what's material? Write that down. We're going to come back to that. Okay? So I just wanted to start with that, Jeremiah.
No, thanks, Kurt. That's a very helpful way to frame things. And let me just maybe ask a general question for the panel as well. When we talk about MNPI and we think about the compliance functions, what role does compliance play?
It's almost like Kurt just said. It's really just educating your staff, educating your associates, your traders, just educating them so they understand what MNPI is, so they understand what insider trading is, they understand the parameters they're supposed to be working in. I'm at a real estate investment advisor, and a lot of them are looking at me going, we don't trade stocks, we don't do that. But we do have interactions with public companies on a daily basis where we do have access to MNPI. And so I have to make them aware of that. So that's really the key, is for people to understand that it does apply to them, giving examples so they can say, oh, I hadn't thought of that, but yeah, you're right, that does apply. So that's what's really, and then reminding people continuously. My viewpoint.
And another area too, so for firms that maybe hear about PIPE transactions, which are private investments in public equity. So when a public company comes with probably a short burn kind of opportunity to privately invest, you have to keep track of that. You have to keep track of who gets the information. You have to put a restricted list together, and you have to have a really robust way of making sure that nobody inadvertently trades. And so part of it is working with your legal counterparts. Another part of it is working with technology counterparts to the extent that you can, because what I've learned over time is it's an area that you really want to automate to the maximum extent possible, because the consequences are obviously very serious.
Sure.
So one thing I'd be curious to hear people's experiences is when you think about your compliance functions and your processes, how much you're relying upon people self-reporting and raising their hand and saying, hey, I think I have NPI, versus other processes where you're doing checks or follow-up. Well, how do you balance those two?
So I think it's a great question. When we think about ethics and our ethics programs, much of what exists in that framework is self-reporting, employees knowing whether or not something that's occurring is tripping a trigger, right? So if we go back to the scenario that I was talking about, we have a conversation that occurred away from work at an event, okay? Say that was on a weekend. Monday happens. You're in your office as a CCO. An employee walks in that was at the event, and they sit down in the office and they say, hey, I was at this thing, a lot of coworkers there, none of the compliance people were invited for some reason. And there was a conversation that I was involved in where the partner of our coworker mentioned that they work at this firm and went through some testing stuff, and I'm concerned that seems like it's pretty relevant, right? So as a chief compliance officer, you're thinking, what? Thank you, right? Self-reporting worked. But did it work? Okay, so one person's come to you and told you something. What else should be happening there if that's now information that you have? So I'm going to probably sit in my office that day and start thinking about what kind of things. Who else was at that party? Who was in that conversation? Where are those people coming forward with this information? So I think to your point, Jeremiah, is you're going to set apart in your program this obligation to an employee to tell you something. And are you going to get every employee on board with the idea of what that means so that they actually execute their responsibility in that way? And coming back to Ivy's point, a lot of what we do as compliance people is train, because they would need to know that. I know one person has come to me and said, I think this is a problem. So that I know that at least one person's identified that, maybe the others didn't. And that's a different problem that now I've got to think about as a compliance person.
Yeah, it's interesting. You're right. That's the first thing that you do. And I've had circumstances where one regrettable one is one of my firms received a call from the Hong Kong regulator saying, we'd like to talk to you about the XYZ company. Come to find out that there was a meeting with some senior people from a company in Hong Kong, and frankly, the folks internally did not believe the senior leadership. I was told that directly, and I said, well, what did they tell you? They said they were going to raise capital. Say more. Well, they were going to raise a couple $100 million. Okay, 200 million? Yeah, it was specific. Did they tell you the price of the stock? Yeah. Oh, okay. So fortunately, nothing bad came from that, but it did not occur to anybody that was material non-public information. And so, when you do get the one person that self-reports, first, absolutely thank them. And I always thank people, even if they come up to me and say, I think this is material non-public information, and then when you come to the conclusion that it's not, you still say, I really appreciate you coming forward because that's helpful. I think the more practical things on the back end is when you hear about it, first thing you do is say, okay, I'm going to think about doing an email search to see if people are talking about this. I'm going to pull information related to trades because have we done any trading within a window of time after they get together? So there are some things you can definitely do, but it is critically important to overemphasize to people, look, I can't be everywhere. Even if you have the largest compliance department, you can't have eyes and ears everywhere. You have to rely on people being smart about it. And I think another really critical thing, and I've been fortunate in the companies I've worked at, is if you can get senior management to attend the meeting when you're talking about things like this and speak to the issue. One senior leader in particular would take 5 minutes during the session where that person wanted to talk about MNPI and say, you need to get this right. This is on you. This is not on the compliance department. So that was my favorite person to work with on this issue.
Yes.
Now, I think in follow-up to that, it's important to help the employees know that, but also remember, as your function as a compliance person, part of it is to manage the risk to the firm, right? And making sure you're protecting the firm's interest here. And so when there are self-reporting obligations, the training aspect, if we go back to the supervision rule, is have you adequately discharged that duty to the employee? And the function of that discharge is how well you train the individual to understand their responsibility related to it. And so if you're not training on MPI or you don't talk about scenarios, then if you have an incident, it's going to be hard to demonstrate an effective discharge of that duty, of saying this person should know to report those types of things to me. That's your benefit to the organization. That's the value add when I go in and talk to senior leadership to say, this is what I'm bringing. I'm helping shift risk to places that we can better manage. And these are the things that make that risk shift so that we can control it better. And then there's tools, which we'll get into later, that help you make sure that that discharge has occurred and that you catch it when it's not.
So we talked about the importance of self-reporting and training, which is obviously related to that. One other way in which people handle MNPI is using information walls of various types. I'd be curious to hear from the panelists what's been effective as far as using information walls from people's experiences.
I'll just start because I'm going to sort of take myself out of that conversation to the extent of we don't have information walls. We're a pretty small shop, and our CEO's view is everyone has access to the information, so therefore everybody, even the admin people, are considered access persons. So we don't have information walls, but one quick thing is I'm always looking for opportunities to train and opportunities to reach out, and as you said, making sure that everyone appreciates it. So if I'm hearing that there was this conversation, I've only had one person report, I am figuring out when is the next luncheon, that's what we're going to talk about. I have my newsletter article. I mean, there's going to be a lot of things. I'm probably sending an email that day going, hey, here's a reminder about insider trading at MNPI, not specific to any one person, but just as a reminder. So we don't have information barriers, but I just think that communication piece and always reminding and training is really important.
Yeah, so before we get to information barriers, one practical tip is just trying to create a buffer for your investment professionals. So, for example, if you're in a shop where from time to time, or regularly, you're hearing about opportunities to do private investments or do something or get greater access to people internally, you work with brokers primarily, you have your analysts talk to companies and make, it's almost like Mirandizing them. I don't want to hear about material non-public information. I don't want to get close. And so it can be more challenging. The less experienced the management team, the less likely they are to be very sophisticated about what is insider trading. It's regrettable, but it happens. Brokers have gotten a lot better. So there's some rules out of the EU that there's a very specific way to wall cross people. And that's for bigger firms filtered over to the US. And so really what they'll do is they want to be placed in touch with the people in usually the compliance department, sometimes the legal department, who can be the point person for identifying opportunities and then deciding internally, okay, is there any appetite to do this kind of thing? And the work in determining that is being done without reaching out to the people in the investment side to the maximum extent possible. So for better or worse, I've worked in a lot of different places that have dealt with information barriers or actually harder walls. So when you're dealing with bank loans, the practice had been that you get more information than you would get if you were dealing in public securities, because technically those are not securities. So in one shop I worked in, we walled off the entire bank loan team, so they were not sitting on the same floor as all of the other investors, and they really didn't talk to them about the companies that they were dealing in. In other situations, it gets a lot more fluid, and my personal opinion is having smaller information barriers with different segments of companies is really challenging, I think, for the reason that you're saying, Ivy, because most firms I worked at look at all people on the investment side as being access persons, and you want sharing of information across the different investment teams to get the best ideas of those different groups. So pulling out different people and saying, okay, you three people are over the wall and you can't talk to anybody, even if you trust people, it's challenging to explain that to a regulator, how it is that you made sure that absolutely nobody talked.
So if we go back to the example, let's say now you've got a compliance person coming into your office, and they say, I was on a video call meeting with coworkers, and as the call was starting, two of the coworkers that were at this parent party that no one got invited to were talking with the partner of one of our employees, and they were talking about this trial experience. And so is that something we in compliance need to worry about? So now you've got one of your team people coming in and telling you, I've overheard another conversation in the firm about something, and there were lots of people on this video call. I want to come back to something because, as Bob was saying, controlling information is hard. I mean, heck, social media, it's immediate. And so when you think about the bleed of something like this, it can happen very fast. And so if you're not quick to adapt to it, what you're going to end up with is restrictions on what you then can do. So hopefully, if that position or that company is not a part of your portfolio or your strategy, maybe the risk isn't as much. But if it is, you've really got a problem in trying to recuse people from being involved in any decision-making related to that position now, right? So not only are we trying to identify who was at the party that might have overheard it, but now I've got an issue where it might be spreading in my organization, and now I've got to figure out how do I stop it from getting any further and finding someone, if we're actually in that position, that can actually act on behalf of the company without having been violated in terms of what they know. So part of that, and I think often one of the things that I would use whenever I was talking to a coworker that was concerned about information they had was this idea of recusing themselves from conversations. If that thing comes up, if anybody even mentions this thing, I want you to walk away, or I want you to just, not participate in those conversations. I might also all of a sudden be sitting in on those meetings and investments to say, I've got to go and sit now and make sure this doesn't come up. Or if it does, I've got to watch who's actually going to be adding some conversation or content around that. So it does add now a responsibility for your compliance team to say, not just the tools we'll get to in a second, but we also may need to do some things that we aren't normally doing. Like, I need you to go now sit in on our portfolio managers' meetings for the next little while until we're going to talk about what has to happen next before you stop. But we need somebody to start looking at the bleed of this and making sure that we've contained it in a way that we can act, right?
There's one thing I'd mention that is an offshoot of that. So I've had people misunderstand the kind of training that all of us have been talking about, where they say, well, Bob, I heard this information, but I didn't tell anybody else about it. And I say, great, partial credit. But what you really need to do is tell somebody in the compliance department so that we can be, frankly, your human shield. Because if you just sit on that information and we don't do the next steps, it's going to be challenging if anything happens because of the presumed knowledge of one person in the company for everybody else.
Yeah. So those are some really good points. And, as Kurt said, we're going to talk a little bit later about best practices and what works for different organizations. We're going to switch gears a little bit and talk about a specific type of insider trading that's been discussed a lot recently, the notion of shadow trading. And for those who are not familiar with this, there was a SEC enforcement action, the Panuat matter. I'll give you a little bit of background here, and then I'll open up to the panel for thoughts and opinions on this. The respondent here was an executive in a business development function for a life sciences company. And as a business development person, he was involved in, merger discussions, negotiations. The company was involved in the merger, but unlike the traditional insider trading where he buys stock in one of the two companies involved in the merger, he bought stock options actually in another company that was involved in the merger, but was in the same industry. And because it's in the same industry, it actually, its stock responded with the merger news. Its stock increased, and he made a profit. And so this is a relatively novel theory. There was recently a motion to dismiss, and the motion to dismiss was denied. So at least a court so far has said that this is a plausible theory that, you know, people need to be concerned not just with the issuers at hand, but being concerned potentially about other companies in the same industry when we talk about, you know, insider trading. And so I guess my first question for the panel is, you know, when I look at this case, I kind of wonder how broadly applicable people think it is, right? Because you could look at it one way and say, this is a very specific set of circumstances. You know, this guy was really in a unique position. He's business development. You know, it's an industry. This is like oncology, like pharmaceuticals, like very kind of like, you know, niche industry. The other company was, you know, very good reason to believe that it would respond to it. And one important thing, which I forgot to mention, is that his company's policy specifically prohibited trading in other securities, which, you know, not every policy has. This policy was broader than other policies have. So I guess the question for the group is this something that we think is just a sui generis thing, it's kind of just a specific set of facts, or we think this is something that's maybe a broader issue that people need to really be concerned about?
So I'll start. So my personal opinion is that the SEC does not like the limitations of the current U.S. law when it comes to having to prove that there's a benefit, having to show the causal link between the tipper and the tippee, and what they really aspire to is having a standard more like the market abuse regime, at the risk of jumping ahead in the talk. But so for folks who aren't familiar with it, since 2016, the market abuse regime has been in place, and basically the mere fact of having material information is something that you have to take very, very seriously. There isn't the requirement to have a fiduciary responsibility to the source of the information. And there are some pretty weird results where, you know, I've been involved in situations where information comes along, it's problematic information, we're already selling a security, and I have been given the advice, okay, you need to continue to sell. Okay, well, but that wouldn't be necessarily the triggering the action that we would take based on the information. Doesn't matter, keep selling. And so I look at a case like this, and it just to me had a lot of echoes of the standard that you would have under the market abuse regime. And the other part too, for people that are familiar with the Code of Ethics requirements under the CFA Institute, for all of your CFA charter holders, there is a higher standard than the U.S. securities laws, which I don't think that people, when they're signing off on the Code of Ethics, really focus in on. Because it's a bit of a nuanced point, and, you know, people in the room here would pick up on it pretty immediately if you've had the chance to look at it, but it's really the idea that if you have material, non-public information, you can forget about all of the other parts that are the elements of an insider trading case, and you're supposed to not utilize that information to formulate any kind of trading strategy. And it'll be interesting to see how this plays out. I think it was at the motion to dismiss stage, right?
Yeah.
And so it's still early in that court case, but if it were to go the way that I think the commission staff wants to go, it could move us incrementally closer to that kind of market abuse regime standard.
So maybe, you know, maybe a case of the staff finding a case with good facts to help maybe broaden.
Yep.
Right.
Yeah.
Right.
The interesting thing about this one and some of these other ones we're going to be talking about is how the way in which you've written your policy or your procedures is what some of these cases are hinging on. And to me, that's fascinating because for those of you that love writing policies and procedures, that's great. But for those of you that just want to get a policy done, this could be problematic because they really hinged on each word within how the policy was written as to how this applied. So if I'm sitting out where you guys are, I would look, maybe dust off that document again, and look at the way in which you're describing what your employees can and can't do with the type of information they may come across in serving the business you're in. And I think in some ways, looking at it from a much broader perspective, if I was at a public company, for example, or something like that, I may already have some confidentiality in my employment that talks about I can't personally benefit from any of the stuff that you're going to learn as a function of your job for our organization. Well, maybe that's the way I need to approach MNPI in our business. And if that's the case, then when you look at some of what's happening with this particular case, they're really looking at how did the person benefit from this? And even if we don't go to a fiduciary obligation, there still is something there to be said for you're taking something that you wouldn't normally have learned, and you're going to go out and do something that's going to benefit you personally as a result of something that we were trying to do for clients that we do have a fiduciary obligation to. So it's interesting because they're still trying to figure out how does this apply, but to me it's almost like that's very unique to see where this could go. So if we went back and we just maybe tie the shadow trading thing into the example, let's say that we have this understanding that there's this pharma company information that's somehow come into our organization and people know about it. And so if I'm a compliance person, I'm going to say, okay, I've identified the people. I know they know this information. It's material we've established. Now I'm going to use my tools, right? And so one of the tools I'm going to use is the trading behavior of the individuals that now know this information. So I'm going to start looking at their personal security transactions. I'm going to see, are they trading this security at some point since that party occurred? Maybe they're using that information to do so. That might be another conversation I need to make. But this case expands that. Because now, if I'm thinking about it, it's like, okay, I've got information about a company whose trials are not good. That probably impacts what? Other manufacturers of that same type of drug now becomes more valuable in the marketplace if that news were to come out. So instead of just looking at a single security and whether my employees are trading it, I now need to think about, well, has somebody figured out that if this company's not doing well, that means these companies probably will. So I'm going to go buy them instead. And so now when I'm doing my PST check, I'm going to be looking at not just that security, but related securities that might benefit from the information that we now know. So to me as a compliance officer, that was like, now I've got a whole nother thing I got to think about when I'm coming across this information, and that's new.
Well, it's interesting. So in my own personal work, there have been real life examples where that sort of thing happens. And so I try to be straightforward with the people that I work with, and they know enough about insider trading law to be a little dangerous, but there will be people that will come along and they'll say, well, I heard about company A, and companies B through E are in the same industry, and because they know, if you have a good analyst or portfolio manager that really knows the industry deeper, they're going to have that kind of information hardwired into their brain. So they know it's a zero-sum game, and somebody's loss is going to be somebody else's gain, and I think that company C is going to be best positioned to capitalize on this shortcoming or foot fault. And then the question comes to, myself as a lawyer or somebody in the compliance department, well, can I trade on that information? Okay, technically, maybe, unless this case goes forward and goes the wrong way, but technically in the U.S., maybe you can. The advice I always give people is I would really strongly recommend that you think long and hard about doing this, because it would be a very aggressive move, and it would be something that we would probably be buying ourselves a lot of conversations with the staff should it come to light. And let me just put it this way. When I first started in 1995, the should it come to light was a very different proposition than now, because the staff, as I think Jeremiah could tell you very well, with the asset management unit, has much better data, and they do call and say, I noticed that you were trading a lot in Company C, and that seems unusual because you weren't trading in Company C for the last several quarters. Could you please describe why that was? Mm-hmm. I don't mean to be too paranoid, but a little bit of paranoia goes a long way.
Yeah.
Well, I think this is interesting, too, because you also have to think about your department and the people in your department. So if we go back to the scenario, nothing's happened. That's not public yet, so we don't even know if it's true, right? We just know somebody said it. So if it hasn't hit the market, there's no action yet in the marketplace to it. And so if I'm talking to a portfolio manager, my junior compliance person who's, just learning the ropes, got to go in and talk to them about, this transaction. If that portfolio manager says nothing's out there, that's hearsay. I'm just buying a separate issue. It's not even related to that. How is that insider trading? And so helping people understand the dynamic of that and who has that conversation is all part of your job. And so, not again to create concern, but these are the things that all of a sudden become we don't have an MNPI problem, all of a sudden become, this is something we may need to talk about. And so this case to me is a learning opportunity to talk about, so that you can start thinking about what would we do? Maybe I need to talk to portfolio managers about this scenario to get them to kind of see the risk associated with it. And maybe I need to talk to my compliance people to say, how would you handle this? How can I help you see the issue? How can I help you figure out how we would address the issue, so that you're in a position to be informative and risk managing with your activities?
So we've been talking a lot about insider trading from a substance standpoint, about whether, what's MNPI and what's insider trading and what isn't. I want to switch gears a little bit and talk about the policies and procedures side of this. And, one thing that's interesting is that a number of the cases that the SEC brings, a number of enforcement actions, don't involve a violation of insider trading per se. It's not having adequate policies and procedures. And so I'm just going to mention two recent cases along this line. So in 2019, there was a case against an entity called MIO Partners. MIO stands for McKinsey Investment Office. I'm sure most people are familiar with McKinsey and Company, the very well-known consulting firm, management consulting firm. They have an investment advisor that manages the investments for the employees and partners of McKinsey. And in that case, there were McKinsey partners who were on the investment committee. They also were involved in McKinsey engagements that involved companies that were invested in by the entity. And again, there wasn't an allegation of insider trading, but they found that there was not adequate policy and procedures, in particular with regard to the people in the investment committee who weren't walled off. That's one example. And the other example is the Ares case from 2 years ago. This got a lot of attention, so I think many may be familiar with it. Ares is a private equity firm. They invested debt and equity in a portfolio company. They had two of their deal people on the board, and they utilized a restricted list. They traded only during an open window. They would check with the people on the board to see if they have an MNPI. So they actually did a number of different things. It did all those things. But nevertheless, the SEC found that it was inadequate process because they didn't check in a detailed way into the specific circumstances that each person on the board had, and they didn't document what they were doing sufficiently. So in both of these cases, there's not an allegation of insider trading. It's just that you didn't quite meet the bar of what your policies and procedures should be. And so my question for the panel is, in light of those cases and people's experiences, how much do you need to do? What do these cases tell us about how high the bar is for policies and procedures to prevent misuse of MNPI?
I think just off the bat, be careful of sort of the tendency to check the box in the way that you work through your policies and procedures. I mean, I think this is interesting because you're seeing an enforcement case where when you look at the particular firm, policies and the procedures and those things were all present. So if you think, I've done a good job, and this is somewhat concerning when you see something like this because it's a firm that's done a good job. They had good mechanisms in place. They just didn't use them to their full advantage. And so to me, this is the area where I think your practice of annually reviewing things is really key, because looking at what did we do, how did we do it, and did it serve the purpose it was intended, Here you had creep, you had information creep. And the compliance people that were responsible for managing the restricted list and monitoring the trades and talking to the director did their job. You know, they did all that stuff. And in fact, no trades were made on the information. So when you think about it as a person in the department, I'm thinking, well, I did all the right things, right? I talked to the director. I've been monitoring the trades. There weren't any trades in the security. We put the security on the restricted list like we're supposed to. We did all the stuff we were supposed to do, except ask the added question of who else might actually be interacting with this information, or who else may that director actually talk to that might also benefit from that information. And even though they didn't act on it, it still flowed that way. And no one in the firm picked up on the fact that that added an added step to the due diligence around managing that information within the firm. So to me, that's the concern. And if I'm already not losing sleep, this would be another thing I would not lose sleep about, because it was a function of something that was set up right, but action and practical application, it didn't do everything the SEC expected. And to me, that's always scary. It's like, but you know, how do I know what I don't know? And so this is the part where examples like this, and I think one of the reasons maybe this was and brought to this point, was to say, don't just be comfortable that you've got all the right things. Make sure you're also doing those things and they're giving you benefit back.
Well, it's interesting. So in a panel yesterday talking about what the exam staff is doing these days, very interesting. One of the panelists mentioned that they'll talk to the portfolio managers and say, so how does your business work? And then they'll turn to the compliance officer and say, so I'd like to understand how you look at this. And it is unfortunate and in certain ways a bit unfair to say, right, we don't want to hear the compliance officer just describe how the compliance program works. We want to make sure that you understand how the business works. And so that's why cultivating the relationship with the business teams is really important, because once they understand that things like this are out here, like this case where basically you do all the right things from a pristine compliance program perspective, but because there wasn't that, maybe there wasn't an open dialogue, or maybe there was just that one extra step that people could have taken. So the stakes are high, and I've seen things where kind of the offshoot of this is you can't regulate against you can't regulate stupid really, and you can't regulate people being people and being kind of busy and writing things in shorthand. But in one of my companies, I was involved in a situation where all it took was a text message between two people on one investment team saying, analyst A said that company B is an interesting, or is a takeover target. I wonder what that means. That's all they said. That led to a 3-year investigation of a person who the analyst was probably the most ethical, compliant person I've ever worked with. It led to that person's personal computers and work computers and telephone being confiscated by the staff. Ultimately, it didn't lead to anything, but it's just one of those things where explaining to people that the stakes are extraordinarily high, that we have to understand their business, we have to partner with them, and if they won't partner with us, then the risks are going to be that we could run into situations like this where something really regrettable happens.
So we have a number of topics we want to do, and we're going to move on to whistleblower discussion. But actually, there's one last question I want to ask on this topic. One thing I think we really haven't discussed yet are the challenges of compliance and supervision in this remote environment that we're in, right? So for the last 2 years, many organizations have a situation where many, if not most of their staff are remote, they're not in the same place. How does that change how people think about compliance? I guess compliance generally, but also specifically in a inside trading MNPI context.
Well, you definitely don't want to allow for out of sight, out of mind. And so in sort of this remote environment, depending on your staffing, but I found myself in every single meeting, anything operational, I wanted to know about it. I sit in on portfolio, I sit on investments, I sit in on IT, just operations, everything, because you want to know what's going on. And someone might not think to pick up the phone or do Teams meeting for you to let you know. You need to know what's going on. The whole idea of understanding your operations, understanding your business, you need to be present. And I'm in every single meeting, and half the times it has nothing to do with compliance or law, but I'm hearing what's going on. And inevitably, there's something where I'm like, wait a minute, you guys didn't document that. Or I heard you talk about this due diligence. Can I see that? Making sure things are documented and just being present and just sort of seeing your face or seeing your name reminds people, oh wait a minute, let me be aware of that. So it's always top of mind.
So two thoughts. First off, there's a little bit of the soft touch that you lose because people who are senior investment professionals will often be more attuned or at least have had more experience. And so if you're all sitting in an office and somebody brings something up or happens to be involved in a hallway conversation, I have had situations where more senior people will pull them aside and say, whoa, okay, we need to call compliance. And those are the good situations. And you lose that because you don't have that, you just don't have that incidental hearing a conversation and having somebody to take the next step. I mean, the other thing too is, so I think Kurt's example is spot on because we worried about the fact that when you have people who are analysts or portfolio managers or usually people younger in their career who have roommates, right? Okay, so at my most recent firm before Jones, we were a blended company, so we had investment bankers who were working from home on deals that were highly sensitive. And, you have to remind them, okay, you should probably have your headphones on. You should not be sitting there with the computer blaring and your roommates are hearing about this kind of thing. On the flip side, if somebody who works for an advisory firm happens to be a roommate for somebody who works at a public company or is an investment banker, you have to, it gets really complicated. It's been kind of challenging to say, okay, how do we make sure that we're tracking all that? Some of it is caught when you ask people to talk about, to have a spouse or a significant other who works for a public company or what other kind of conflicts are out there. But, again, gathering the information is just the first part. Then you have to operationalize, okay, how we're going to track to make sure that we know that the person isn't stepping into it inadvertently or doing something worse.
Yeah, sort of follow up on that, Jeremiah, when you think about the displaced workforce or working remotely and the office sort of expanding, things that we didn't think of before. So, Bob's right. We really miss the being around to and accessible. But it also means that now your business is in homes and apartments and other things. And so how well do you know those circumstances? When I was at CCO, I didn't really want to talk about their personal life, and what their living situation was. But now that we have an office there, this becomes part of things that we need to understand. How are you working? If I'm on a video call and they're sitting on their bed because that's their office now, is that, the best thing? And does that create some issues of how that employee's doing their job? I think the other thing that's interesting, and we've seen this too, is why regulators are so focused now on electronic communications, right? So that should be a new focus for you if it's not already, in expanding the use of email. Because now with video conferencing and the ability to message through these apps and use text messaging, as you mentioned, Bob, how are you gathering that? Because really your surveillance, your insight is going to be in those communications. That's much more freely done because they can't do it face to face. And I think that substitute should be something that if you're not addressing or not considering in your program and in your tool chest, should be, is how are you communicating? Are you using team chat? Are you using phone text messaging? How are we able to see those conversations to gain the insight? Because I'm not getting the water cooler anymore. How am I going to get it otherwise? And so I think these are things like, in most cases, our programs need to evolve. We need to recognize the change in our work environment. We need to understand the new risks that are being introduced to it, and then help the firm figure out how do we mitigate or manage that. I need as compliance tools to have insight into the way that our employees are operating now. And if this is something they're going to start doing, we need to figure out the way we're going to remediate the risks associated with that type of communication or that type of activity now that we're working from various locales and different circumstances.
Well, and the other thing too is, so my least favorite part of the job is acting as cop and in kind of things that people chafe at. So text messages, right? So if it's a Teams message, we can capture that, right? But text messages, they don't work, right? You can't track them, generally speaking, and really what it comes down to is the JP Morgan thing. I mean, for anybody from JP Morgan Asset Management, apologies, but it's nothing like $200 million fine for no underlying substantive, issue, but just for failing to have your act together and failing to enforce the rule that you can't use text messages. And so that is something where I think there's been slippage. I think there potentially has been a lot of slippage when it comes to, that area. And that's the kind of thing where you just have to take opportunities. As Ivy was saying, when you see something that's happening out in the world, you just remind people, hey, look, this is a really big deal, and we need to get on top of this.
So let's talk about the SEC whistleblower program. This has been one of the really big innovations at the SEC. The program's paid out more than $1.3 billion in awards. There have been some massive awards, a couple above 100 million, many in the tens of millions. This has really become an important source of cases for the staff. And so my question for the panel is, how has the popularity of whistleblowers and the way the SEC uses that? I guess a couple questions. How has that made you think about your own internal processes as far as maybe trying to have a process where people reporting internally first, because as people may know, they don't have to. There's law and precedent saying people can go directly to the SEC. They can do it either way. So how do you encourage people to report internally? And how's the whistleblower program changed how people think about their compliance functions?
I'll say whenever we have new hires, I meet with them to explain, because again, real estate, people don't necessarily think about securities laws. And that is one of the things I explain about the whistleblower program. I let them know that they can go to a regulatory body, to the SEC, but I also ask, please let me know, because we take this very seriously, compliance here, and I need to know if there's a problem. I need to know immediately so I can start looking into it. I'm not preventing you from reporting elsewhere and doing the anonymous. We have it set up so that there can be anonymous reporting as well. But please just let me know as a courtesy, we'll say. But just, keep those communications channels. If you see something that doesn't look right, call me immediately. We'll work on it. If you still feel you need to, report elsewhere, I support that. But just making sure they know, where I am whenever you see these large awards. It always goes, maybe I want to go that way. But, if you're really at the firm and it's the firm culture that we all support each other, then it's let us know also so we can clean up if there's someone who's a rogue actor.
Okay.
So I saw we had a question. I don't know.
Yeah, we do have a question. So let me ask, so we have a question. This is, I think, we were talking before about the challenges of remote work, and I think this is really relevant to that. So is there a viable solution to capturing client text messages? What is your recommendation on how to handle this issue?
So I take the question, and I have heard that, okay, well, Bob, my client prefers to communicate by text. How do I talk to them and not put them off by saying to them, hey, listen, we need to, I'm going to email you back. So the first thing, obviously, is try to get them to a channel that can be captured. So I know there are tools out there. I'm not aware of one that works for iPhones. I know that there was some effort at my last firm to really tackle that because, with no offense to folks that make Android phones, they're not as prevalent as iPhones. And so, Again, with teams, that has been something that has been a little bit more helpful, but it's challenging when your client reaches out. So, I mean, the couple of things from a practical perspective, we've told people, first and foremost, see if there's any sort of way you can get them onto a channel where it can be captured by the firm system. Short of that, just start taking screenshots and sending them to you by email so that you can capture it in some way.
Yeah,
I'll be the first to say there's no clean or easy or non-cumbersome way to do this.
yeah.
Unless Kurt might have.
I think you're right, Bob. But the nice part about it is because it becomes an issue, hopefully that makes service providers see an opportunity to provide a solution. So maybe that's coming. But in the interim, I think the important thing to think about is what does your policy say first? I mean, do you restrict it or allow it? And if you allow it, how do you allow it? And what do you require the employee to do if so? But there are some steps. I don't think any of them are perfect, like you said, Bob. Obviously, you always get they're using their personal devices versus a corporate device. If they're using a corporate device, you have a little bit more control. You might be able to gather that information a bit more easily. If they're using a personal device, very difficult in order to do that. To Bob's point, if you have text messaging, you can print that stuff. You can get copies of that stuff. It's not going to be comfortable, especially if it's a personal phone, but they can, there are companies out there. There's also apps that can take the entire chat messaging function of the phone and copy it and put it into a PDF so you can lift it off the phone and put it into your system so you can monitor it. Don't really care to know all the text messages that people have, but it's all or nothing in some of those cases, or they can just print those individual messages. But just remember that if you push that over to the individual, you have an obligation then to test the effectiveness that they're doing what they're supposed to do. So if you say, make a copy of whenever that happens and get it to us so we can put it on the system, now I've got a duty to test the phone to make sure that they're actually doing that and they're copying the ones they're supposed to. Maybe you don't want that obligation. And remember that the SEC is going to look at whatever you're doing and saying, is that reasonable? So it might not be comfortable, but if you're going to allow certain things, you got to think about how do I handle the burden that's associated with managing that.
Right, and from a really practical perspective, because I've known plenty of people that have adopted the approach that they'll have a work phone and then they'll have their personal phone. Going back to the example that I gave, nobody wants to hand over their personal phone with all of the messages and other personal information to any regulator. Android does have the ability to track the text a little bit. It depends on the size of the firm and depends on how seriously they take this or how much of a problem it is.
Yep.
You could mandate or try to get it mandated that people have a dedicated work phone so that the monitoring would be a bit easier.
There are some soft phone technologies out there, so especially now that we're working remote, many firms have gone to soft phone functions so that you can move your phone around to different devices. Some of those have the ability to put a soft phone on a cell phone so you can keep the same corporate number but utilize your personal phone to answer those calls. Some of those come with text features. Again, I'm not an IT person, so that I know enough to be dangerous, I guess, on that. But there are options, and so, be certain if it's important, and as Bob said, if it's a part of your business, those might be things you have your IT department search for you.
So before I forget, let me give the second code word for continuing education credit. The second code word is Socrates. I don't make these up. I'm just handing it. It's Socrates is the second code word. So we're almost out of time here. I just want to give people, if there's any, quick best practices or tips or things that we didn't cover that people think would be helpful. I just want to give people an opportunity to mention.
I'll give them a couple of things to take away, right? First, make sure you have enhanced, targeted, and interactive training with your people, right? So if we've learned nothing about these cases out there, training is critical to your handling of this. Second, make sure you add to your risk assessment this area and you identify where a possible bleed of information is in your organization. Third, review your policies and procedures. I'd go back to these cases and look at the wording of their policies, because that's really important, and think about that in the context of how you stated in your code of ethics or your insider trading policy. And then lastly, we didn't cover it in a great deal, but it does talk about NDAs and confidentiality agreements, and the language in those should be something that you're looking at. So if you're subject to those, or if you have relationships where those things are a part of your business, as a compliance person, you should know that. And you should know who it's with and what the terms are and those kinds of things as well. So, you know, nothing for you to worry about at 9 o'clock in the morning, but, you know, I think we're almost out of time on the subject, and hopefully this was helpful for you as well.
Thank you to the panelists. Thank you, everyone, for participating. Thanks.